Hello and welcome. Thank you for joining today's Doing Business in the U.S. webinar, Accelerate Your Food Processing Business. My name is Olivia Hill, Senior Business Development Specialist here at Invest Buffalo Niagara, the region's nonprofit, non-government economic development organization. I'm happy to welcome a number of legal experts joining me today and would like to invite Laura Bechtel, who is joining us from her Toronto office, to introduce the Hodgson Russ team.
Hi, everybody. I'm Laura Bechtel, a partner in the Toronto office of Hodgson Russ. I'm broadcasting live from downtown Toronto with my colleagues here from around our firm. My focus at Hodgson Russ is on labor and employment, but I have with me Christine Bonneguide, Nathaniel Lusick, and Mike Maxwell, who specialize in other areas that are going to be relevant to any business expanding from Canada into the US. Hodgson Russ is a full-service, business-focused law firm that's based in Buffalo. We have offices throughout New York State and an office in Florida and, of course, Toronto. And we have one of our special focuses is on helping Canadian businesses expand and do business in the US. So we're very pleased to be here with you today. Dean is going to speak to you on the corporate considerations and general business considerations you need to think about as you approach a cross-border expansion. Daniel will praise us on the basics of protecting your brand, trademark and intellectual property considerations for your industry in particular. And then Mike is going to share with us some ways to approach and to think about handling the US regulatory environment for the food processing business. So with that, I will turn it back to Olivia and let her ask you a couple of polling questions.
Sure. Thanks, Laura, so much. Like Laura mentioned, now that you know who we are, we'd love to get to know a little bit more about our audience. So we've got 3 quick poll questions. I'm going to pull up our first one now. Are you currently selling or shipping products in the US? I'll leave this up for a second or two for everyone to answer. So first response, we've got 75% say no, they're not currently selling or shipping into the US, and then about 25% saying a little bit of their businesses here in the US. So jump down to the next poll. Are you considering a business expansion to the US? Again, I'll give you a couple seconds. All right, so now we've got about 60% saying yes or maybe to wanting to expand to the US, with a few of you looking within the next 12 months. What is your biggest concern with structuring operations in the US? 100% say lack of knowledge. So you've come to the right place. We think we have some good information for you today. So with that, I'll jump into a little bit about Invest Buffalo Niagara and how we can help. There are various reasons why Canadian companies would consider an expansion to the US. A key one is access to the US market. On this map, you can see what areas of the US can be reached within 10 hours of the Buffalo Niagara region. Our strategic location on the Canadian border is within 500 miles or 800 kilometers of 40% of the binational region. Other reasons for US expansion include proximity to customers, proximity to raw materials, made in US requirements and opportunities, mitigating liabilities for the parent company up in Canada, as well as mitigating potential costs and delays that come with shipping across the border. Buffalo Niagara's proximity to the Canadian border is a major benefit to locating in the region. Canadian companies can access both their Canadian and US facilities within a short drive. Other benefits of locating here include low-cost hydropower, a highly skilled and affordable workforce, and abundant, fresh, clean water. Of course, those are incredibly important for food processing companies as well. And of course, another great benefit is a 0% state corporate income tax rate for food processing companies. And for dairy companies specifically, you'd be joining the ranks in the 4th largest dairy producing state. We have sites in our region specifically designed and equipped for food processors with impressive neighbors, including HB Hood and Canada's own Pride Pack. The team at NBN can walk you through your US business expansion in a variety of ways, including what we refer to as cross-border due diligence. Along with our regional experts, some of whom you'll hear from today, we educate you on the tax, legal, banking, and HR considerations for a US business. We also help with identifying suitable real estate and coordinating site visits, incentives coordination and applications, local partner introductions, utility introductions, and more. And all of our services are free of charge. So whether you're thinking expansion in the next 6 or 12 months or potentially 2 years down the road, it's really never too early to get in touch with us. And with that, I'd like to turn it over to Christine Bonneguy to talk about structuring that US expansion.
Hello, I'm a corporate lawyer. I'm going to talk to you about some of the business aspects of structuring your U.S. expansion or your cross-border expansion. And so there's a variety of ways to establish a U.S. presence here, and we assist Canadian companies with any and all of them. And you can see sort of the list: direct sales, which many of you probably already are familiar with, and then either going to a distributor, selling products to a distributor for resale in the US, or using a sales rep on a commission basis. Some folks establish branch offices here in the US as an initial step, or they just go straight to forming a US subsidiary. Other alternatives, if you have sort of a business partner that you could pair with here in the US, you could establish a joint venture. There's licensing and franchising opportunities, and also a quick acquisition. You decide there's an existing US business, my Canadian company will buy it, because it's more of a turnkey situation. I think the most frequent, at least to start, way that Canadian companies expand into the US is they'll create a US entity, a subsidiary, maybe not a direct subsidiary of your operating company. And in the US, this is a state process. We don't have a federal process like they do in Canada, where you have both your provincial and federal process. The first step is to determine what type of entity you're going to want to use, and the driver of that will be tax, which I'll talk about next. But initially, you need to think, where do I need to form? And it doesn't need to be in the state where your business will be operated. Delaware is a very popular place of formation for US entities, even ones that are never going to actually physically be located in Delaware. You'll have to think about what your corporate name will be. The state will have to approve that, but the state's approval of your subsidiary's corporate name doesn't give you protection against IP infringement, and one of my colleagues will get into that, and trademarks and service marks to protect your IP. What the new company will need is an EIN, an employer identification number from the IRS. And that is to set up your bank account, to set up your payroll, to make tax filings in the US, you're going to need an EIN. This is something that if you don't have a responsible party, somebody who owns and controls the company with a US social security number, again, good to plan ahead if you're going to need to open a bank account and set up payroll. Once the entity is formed with the state, it will need to register with the state taxing authorities in whatever states it's going to be working in. You may need it to obtain a certificate of authority to do business in other states. That's like an extra provincial license. It'll depend on the level of activity. Will you have employees and operations in other states? And the last thing I would say here is you'll need to pay very close attention to the separation of the corporate forms. So your Canadian company and your US company do need to have different bank accounts, different books and records, and you need to respect the corporate forms to have it viewed as a separate legal entity. Next, I wanted to just touch quickly on some tax considerations in the US entity structure. And what we typically do is we work with our Canadian clients, Canadian accountants, to plan the appropriate organizational structure, looking at your Canadian organization, ownership, operations, and then some of these questions about what you expect from your US operations. So will there be significant startup losses? What will happen with profits? Are there US investors or people involved, or will you need visas to come to the US? What's the exit strategy for the business, ultimately looking 5, 10, 20 years down the road? And then, looking at all of those issues, we'll take a look at the type of entity before it can be formed with the state. Usually U.S. corporations are used because the LLCs may not qualify for treaty benefits, but if you have U.S. investors or owners, you may need to use an LLC, and so we would need to structure the Canadian ownership appropriately. For example, there may need to be a blocker corporation in the U.S. or other structuring considerations. Other issues that the accountants will think about with us are, do we need transfer pricing agreements? What's the level of debt versus equity that needs to be in the U.S. company? And then, what's your estate plan? Do you, as an owner, don't necessarily want to have U.S. situs for assets for foreign residents? Thinking about planning for your products, what is your U.S. import strategy? We always advise you to work carefully with your freight forwarders and customs brokers to get everything ready on the import-export side. If there's any appropriate governmental license or registrations or approvals, those are all things to put in place. There may be IP licenses that you need from your Canadian operations to your US operations, or maybe from third parties. You also will need to think about things like rules of origin to determine what kind of duties and tariffs and taxes on the goods will be, and quality standards as well. I wanted to say a few words specifically about importing meat and dairy and animal products and plant products. So your products have to originate from certified countries and establishments that are eligible to export to the United States. APHIS, which is the Animal and Plant Health Inspection Services here in the US, restricts some products from entering the US because of animal disease conditions in the country of origin. So that's something that gets looked at before products can come in. Countries and establishments will become eligible after an equivalence determination process by FICIS, and then imported products have to meet the same labeling requirements as domestically produced products. So after you file the necessary forms for U.S. Customs and Border Protection and you meet your animal disease requirements of APHIS, then the imported meat and poultry and processed egg products have to be presented for inspection by FICIS at an official import establishment. FICIS I'm referring to is the U.S. Food Safety and Inspection Service, which is a branch of the U.S. Department of Agriculture, which is assigned to oversee import regulations for meat, poultry, and eggs into the U.S. The company may need to be registered with the FDA and have proper licensing in Canada as well. Your facility may need to be registered for FDA approval, so there would be an in-person inspection for that. Then the company will have to determine what imports the U.S. is accepting from the given country. So for example, for Canada, things like eggs, products, meat, and poultry. But you also need to look to not only the country where the product is manufactured or refined, but also the country of origin of the products. And then for plants and plant products, they also have various U.S. import requirements. Another important step in getting up and running, once you've got your established operation here, is your contracts, form, and policies. You will want to Americanize them with U.S. legal provisions and make sure you think about things like what's the currency we're going to get paid in, and how will you get paid, and what is the payment timing for your Incoterms, and when does title pass, and risk of loss, those kinds of things. And enforceability, are these contracts going to be enforceable in the US? Contracts with your customers, your suppliers, your other business partners. With that, my colleague Mike Maxwell is going to speak to you next on pitfalls and food labeling and packaging.
Thanks, Christine. I'm Mike Maxwell. I'm the head of the litigation department here at Hodgson Russ. A lot of what I do, and people think about litigators as somebody that represents you when you get sued, the person that comes in to put out the fire. But more and more, litigators are using their experience in litigations to help mitigate risk that people have when they come into the US market. I work a fair amount with Christine on contractual issues, trying to provide the right provisions and contracts to eliminate or mitigate risk that you have, or at least put that risk on someone else. But also there are some other things that you can do to try to make sure that you don't get yourself in trouble, either from a regulatory perspective or from a litigation perspective. We are federally regulated in almost everything. You know, we're one of the most well-regulated societies in the world, including food. At the federal level, the Food and Drug Administration, the FDA, is the entity that does that. And there are regulations that are particularly relevant to food, and that is that any food product or food additive has to be approved by the FDA before it is sold as a food product. And that can be approved in one of two ways. There's something called the generally recognized as safe list, the GRAS list, and that is, it's about 580 different things that are generally recognized as safe by experts in the area. If it's on that list, you're good to go. If it's not on that list, you have to get pre-market approval. So what if you don't? Then you are potentially subject to a recall action. You have to recall the food. And that's because it's considered an adulterated food product if it is sold when it's not been approved by the FDA. If someone is harmed by your food or food product, then there's a potential piece of litigation with respect to that injury. But generally speaking, you are insured for that. Recalls, on the other hand, can be extremely expensive. In other words, it's an adulterated food product, didn't hurt anybody, but all of it has to be pulled back. There is insurance available for that, but it's prohibitively expensive, and it's pretty limited in what coverage you have for that. But there are circumstances in which it does make sense. So federal law is overall is the primary thing here, and federal law in the US preempts much state regulation, but state regulations can supplement federal law. And obviously we have 50 states, all of them have different laws. The one most noteworthy state regulation with respect to food, and frankly, most products in the US, is what's called Proposition 65. And it's the technical name for it is the Safe Drinking Water and Toxic Enforcement Act of 1986. So how is it set up? There's a list of over 800 chemicals that if you have any of those chemicals in your product, then you have to include a warning label for consumers in California. And you might say, well, you know what? I'm not going to set up shop in California. It applies to anything sold in California, including internet sales. So what has happened is that consumer groups, and I use air quotes there, and I hate that, but I'm going to do it anyway, because those consumer groups are generally set up by plaintiffs' lawyers. And what they do is they scroll through the internet trying to find products that may contain one of these listed chemicals. And if they find that, and it has not been warned against, then they are allowed to commence an action. Why this is particularly relevant to food and food products is because the list of chemicals includes acrylamide, lead, and cadmium. Acrylamide is something that occurs during the baking process. So a lot of snack foods, baked and fried snack foods, include acrylamide. And lead is important for particularly things like dried fruit and spices, because lead, depending on where the product is grown, lead and cadmium can leach into the product itself. There are some exemptions where you don't have to warn. One of them is if you have 10 employees or fewer, then you don't have to comply with this. The other one is if you can demonstrate that the exposure level in your product is below a certain threshold. And that sounds great, right? But testing the product to prove that is extremely expensive. It's far easier to put an appropriate label on. So let's talk a little bit about litigation, food litigation in the US. And I know there's some significant class action litigation in the food space in Canada as well. It's usually in the false labeling area. You know, you say you have this much sodium in your product, it turns out there's that much sodium in the product. In the US, it's expanded beyond just false labeling. And the definition of false labeling has been pretty stretched, or attempted to be stretched, by plaintiffs' lawyers. If you put all natural on it, they're going to say, wait a minute, that's not all natural, it's processed. If you say it's vanilla flavored, they'll say, well, it's not just vanilla. There's also some other chemical flavorings there, so it's not pure vanilla. Those cases are kind of going away. The courts are saying, come on, if it says if it tastes like vanilla, then it's vanilla flavored. So the courts have been pretty good on that. Place of origin is an interesting one. The Cape Cod potato chips, with a lighthouse on it. If you use a name and use graphics that show that demonstrate a particular geographic region, and you're not making it in that region, you can get sued for that as being misleading. Cape Cod potato chips are, by the way, made on Cape Cod, so that's good. A case that came out last year is particularly relevant to this audience. It was for a mustard called, it's M-A-I-L-L-E. It's a French word. There's French language on the label. There's an emblem of Paris on the label. Plaintiff's lawyer sued it saying, hey, this is misleading. It's not made in France. And the court, to its credit, said, well, it's not made in France, but they speak French in other countries, and it says right on it, made in Canada. So that case was thrown out, but the point is they got sued over it. So you do have to be careful about geographic designations, because again, the idea is to mitigate risk, get rid of getting sued, so you don't have to spend money on that. Slack fill is how much, when you buy a bag of potato chips, it's half air. People have complained about it for years, and plaintiffs and lawyers have sued people saying, hey, this is misleading. I thought I was getting this much and I only got that much. Those cases are relatively hot right now. The courts are starting to weigh in on what's important and what's not, what can be sued for and what can't. Animal welfare is something that's coming up. If you use cage-free or free range, then there's some cases now saying you're not treating the animals in the way that implies. So there are some lawsuits about that. So that's a trend we see. Anyway, so litigation as a whole, it's important to make sure that you mitigate those risks. So I'm going to turn it over to my colleague, Nathaniel Luchik, to talk about IP.
Thanks, Mike. So my name is Nathaniel. I'm one of the IP attorneys here at Hodgson Russ. I'm just going to give a very quick tutorial introduction to trademarks, patents, and IP protection in the United States. The two we're going to focus today on are going to be protecting your brand, your slogan, your logo, which would be with the trademark. The other option that we're going to talk about protecting would be your methods, your recipes, your designs, which would be a patent. Two things to remember as you evaluate your intellectual property protection in the US. One, it's country specific. So if you want to try to stop a competitor here in the US, you need a US patent or a US trademark. The other thing to remember is from the patent side, it would be great if you could obtain protection on your recipe or on your food product itself. That can be challenging, and that's because people have been baking and cooking for thousands of years. So you need to have an innovation that's truly new in order to get that. People get around that by using trade secrets to protect their recipe, which again, people have been doing for hundreds of years. Trade secrets are great in the United States because they're free. There's no cost associated with them, but they're limited. And that is, if someone reverse engineers it independently, you have a difficult time stopping them, or it might be impossible to stop them. Patents give you a little bit more flexibility to stop someone, but they're more difficult to obtain. So that's something to think about as you're talking to a patent attorney, to find the best strategy to protect your recipe or your food product. So trademark is just something that designates a source of origin. It's what distinguishes your brand from someone else's brand. It could be a word, it could be a logo, it could be a phrase or a slogan, it could be packaging, letters, numbers. The point to remember here is you want something that is more unique. So something fanciful like Xerox or Exxon. Those weren't words. They don't exist in the dictionary. They were invented. The other option would be something more arbitrary like Apple for computers. There's no connection between Apple and computers. What you don't want for your trademark, which makes it much more difficult to register, is something that's descriptive like tasty. Tasty for potato chips. The US Trademark Office isn't going to, it's probably not going to allow that. Or something that's generic. So juice for juice or apple for apples. You can get apple for computers, but not apple for apples. So something to remember as you're choosing your brand, if you haven't done so already. There's a spectrum of distinctiveness that can make your life either much easier or much harder at the Trademark Office. The process is exactly like you'd expect. You choose your name, you choose your mark, you go through the steps. What I will mention for new companies starting out, if you already have an established brand, then that's what we search. If you're a new company starting out and you're trying to come up with your brand, steps 1 and 2 on this list tend to be the most challenging or the most difficult or time consuming. That's because they might be in a loop. You might bounce some ideas off your US trademark attorney, who then either searches to look and see, could you actually register this, or could you use this in the US without getting sued, and says, no, go back and you start over and brainstorm a new one. So why did you go through all of this? Well, it's to get the registered symbol, the circle R. You can only use the circle R if you have a registered trademark at the US Patent and Trademark Office. And you can only use it with the goods that are linked to the registration. When you register, you have, you list the particular goods that go with your trademark. So if you say it's, I'll pick on tasty for potato chips, you can't put tasty on milk. That's a weird adjective to use with milk though. So this is helpful. The circle R is helpful because it notifies the public. Do use it though, because if you don't use it, you're not putting the public on notice. It can impact your ability to get damages if somebody copies you. The two that I want to point out here, the first at the bottom, having a registered trademark can help you block imports into the United States. And we've worked with a number of government agencies in the United States to do that. So that's a definite benefit. The other one being is the first one on the list, that you receive national protection. So if you are in Canada and you start selling into beautiful Buffalo, right outside my window here, you get some small amount of brand protection under New York state law. So if someone else is making the same product, they're using a similar logo, you might be able to stop them in New York state. But if they're just south of here in Pennsylvania, or they're in Texas or California or somewhere else, and they're using your brand for your products and you've never sold there, your chance of stopping them goes down drastically. Which is the reason why you get national protection with a federal trademark registration. Then you can stop them in any state. You can use federal courts, you can use federal statutes to calculate your damages, which are all significant benefits. I'm going to briefly mention the two types of patents that might apply. There's actually a third type in the United States called a plant patent, which protects plant varieties. I'm going to skip that one today. Utility patents are exactly what you'd expect. Could be process of manufacturing, it could be your manufacturing equipment, it could be the software that runs the equipment, or it could be the food product itself. All of those things can be protected. I've got some examples in the upper right, which shows some chocolate. And that process is exactly, it's almost exactly like what you do up in Canada. The timeline's different and the actual procedures are slightly different. Same idea. Design patents are the other way to do it, and I've got examples at the bottom. Design patents are pictures. You have one sentence that explains what it is, and then it's just a series of pictures. So if you do have a unique container, you have a unique tray, a bottle, or even a food product. I've got the little dinosaur. I don't know if it's a cookie or a noodle, but you can protect the food product itself if it's got a unique shape to it. The advantage with design patents, they're usually fairly easy to obtain as long as you're not copying somebody else's design, and it's very easy to calculate damages. You skip some of the damage calculations in a lawsuit that are in a utility patent application, patent infringement suit. Two quick things as I wrap up here to remember with patents. One, if you've been selling your product for a long time, there's a good possibility you can't get patent protection at this point. The United States does have a grace period, but depending on when your first public disclosure was or when your first sale was, you might be outside of it. So talk to a patent attorney and see if you can even protect with a patent. The other thing is, which is going to lead into our next presenter, in the United States, if you do have US employees or contractors that are doing your development, remember to have them sign an intellectual property ownership transfer or ownership agreement when they join the company. The standard in the US is that the inventor will own the invention unless there's an agreement that specifies otherwise. And what you don't want to have happen is after your sales increase dramatically, you go to them and say, hey, the shareholders would really like it if you transferred ownership so we can do another funding round. And they say, yeah, no, thanks. I'd much prefer to have a royalty on that. So that's something to always think about. And with that, I'm going to turn it over to Laura, who's going to tell you of hiring a US workforce.
Thank you, Nathaniel. I'll tell you some high-level concepts that might help you with your planning and your considerations as you hopefully have a lot of success in your U.S. expansion and want to have a U.S. workforce along with that. In one way that the U.S. is different from Canada in the workforce law area is that there are many sources of workplace regulations. As you know, as Mike indicated in his area, the federal law, covers the country, but in the employment law context, the state regulations and sometimes even county and city regulations supplement the federal law. So the federal law sets a floor, and I've tried to sort of describe it visually here, of employment regulations. And then the states and the counties may put additional employee protections or restrictions on employers on top of that. And so it's important to keep in mind that when you have employees in the US, you need to understand not just your obligations under federal law, if there are any, because sometimes they will only start applying when an employer reaches a certain size, but also under state law. And so it's not the case where you're either provincially or federally regulated. But in another significant way, employment in the US is much simpler for employers than it is, at least in Ontario, which is the province I'm most familiar with. The concept of employment at will, as far as I can tell, is relatively novel to the United States. And this is the default presumed status everywhere across the country. There's a modification in Montana. But what employment at will means is that no contract is necessary, right? Employment is for no particular term. It's indefinite until either side, the employer or the employee, just wants to end it. No notice is required to terminate at any point in the employment relationship. Cause is not required to terminate. And you can terminate an employee for any reason that's not unlawful. So that means you can terminate someone because you just don't like them anymore, as long as it's not because of their membership in a protected class. And you can also, as an employer with an at-will employee, unilaterally change the terms and conditions of their employment. And there's not an equivalent concept of sort of constructive dismissal as we see in Ontario. And so if you had an at-will employee and your business was facing constraints in some way, you needed to reduce their compensation by 50%, you could go ahead and do that as long as you were still meeting your minimum wage obligations. And so that means there's no severance, there's no termination pay, there's no pay in lieu, and there's no need for a probationary period. Because one way you can think about employment at will is that the whole employment period is a probationary period. Sometimes that's a helpful shorthand way to explain it. Now you can have deviations from that very sort of employer-friendly at-will standard by virtue of making a promise to the employee of some sort of notice period or severance or termination in the event of heightened protection against termination if they say satisfactorily complete a probationary period. If you make that promise in a contract or in a policy that you inadvertently created sort of a binding obligation on the employer, you could have deviated from the at-will standard. Of course, there are statutory and public policy exceptions to employment at will, and this is what I meant when I said you can terminate someone for any reason that's not unlawful. So the non-discrimination laws, right? You can't terminate someone because of their race or gender or age or disability or military status, etc. Those are considered exceptions to at-will employment. Same thing with protections for whistleblowers or employees who complain internally or externally about what they believe in good faith to be violations of laws or who exercise protected rights. Can't retaliate against an employee on that basis, but otherwise, employment at will is the larger context. Of course, collective bargaining agreements in the event you have a unionized workforce, that is a major deviation from the at-will employment standard, as are severance agreements or severance plans that are, employers may voluntarily adopt or enter into. And again, want to be careful about inadvertently altering the at-will status by adopting policies that restrict an employer's ability to discipline employees or change compensation or terminate employees for any reason that's not unlawful. I also wanted to, rather than get into a lot more details about the various laws, because in some respects, the wage and hour laws and the non-discrimination laws, obligation to accommodate disabilities, they have analogs in Canadian law that would not be unfamiliar to you. But I do want to take a minute to advise that before you find your perfect candidate in the US that you want to hire, take some time to go through this checklist of items that you will need to sort of have ready for day one with your new hire. So before you've sort of even made an informal offer to somebody, make sure you do have that employer identification number that Christine mentioned. We've seen lately that has just been taking some time, and that comes from the Internal Revenue Service, and there's nothing that can be done to speed them up. And so if you're going to need an EIN to register with the state, to withhold, to properly have a payroll, and to open a bank account, you'll want to have build in some lead time for doing that. New employers have to register with one or more state agencies, usually to sort of alert the agency that you're going to be hiring employees in that state, and that you may be remitting withholdings and income taxes, et cetera, from payroll. You'll want to obtain a workers' compensation insurance policy. And if you have one that's applicable in one US state and you're expanding into another state, you will want to be sure you let the carrier know that you're going into a new state so that you can get proper coverage added onto the policy. There are, at the state level and sometimes the local level, required notices that have to go to new hires. Sometimes it's about, the time and form of payment. Sometimes it's about the right to certain statutory paid leave or unpaid leave, as the case may be. You'll want to think about whether you're going to be providing this person with a conventional at-will employment arrangement, in which case you would want to have an offer letter to set expectations. If this is going to be a salesperson that you're hiring, and oftentimes it is a salesperson who's the first hire, it's very important to really think through and iron out and articulate in writing, particularly in New York where this is required, all the terms of the commission, how it's calculated, if there's a reconciliation, when that happens, how frequently it's paid, et cetera. You will want to think about also what you're going to do about leave, vacation, and get a basic understanding of the leave laws applicable in the jurisdiction where this employee will be primarily working. We've seen leave laws, paid and unpaid leave laws, really proliferate at the state and local level in the last 5 or 10 years. There's no requirement to provide vacation or holidays in the private sector. But there's starting to be requirements to provide paid sick leave or to participate in sort of state regulated paid family leave programs. Also benefits, this can be intimidating, I think, for Canadian employers. If as a small employer, there's no obligation to provide health insurance to your employees. And from a competitive standpoint, you may need to have some sort of employer-sponsored plan that the employee can opt into. Costs are typically split between the employer and the employee for those. So build in some lead time for sorting through, maybe with a benefits broker, what you'd like to provide to employees before you have a candidate that you love sort of saying, hey, I can't come unless you have a health insurance plan. And so just, it's all very surmountable. If you have a payroll provider in the US, a well-established, reputable one, they'll be able to do it and to sort of assist you with many of the mechanics, but just want you to be thinking about that ahead of time.
Thanks so much, Laura. I appreciate you rounding out the Hodgson Russ team. And before we jump into our Q&A, I just want to touch on a few things and a few resources you can find at buffaloniagara.org, the Invest Buffalo Niagara website. We have a great agribusiness brochure, as well as some Canadian guides to business expansion. We have 3 volumes chocked full of good information, touching on some of the things we talked about today, as well as diving deeper into topics along legal, accounting, HR, banking, all those considerations for a Canadian company. We'll be sure to send a follow-up email with some additional information after this webinar and answering any questions we don't get to in the next few minutes. So starting off, a good question I'll kick it off answering and have our panelists jump in. How has COVID impacted Canadian business expanding to the US? So from my end, we continue to see Canadian companies continuing to explore US expansion. I think for many Canadians, it has pushed them over the edge to wanting to have some sort of presence here. Obviously, we never predicted a few years ago that we would be seeing a restricted border, and as a cross-border community, we've come to know the ease in which we've gone from country to country. So I think that Canadians continue to push this. This is a logical next step for Canadians selling into the US market already. But something that our panelists touched on, and I wouldn't mind if one or two of them would jump in on this as well, is the timeline for things. So, it was mentioned the EIN might take a little bit more time, and building in some leeway for that. So I don't know if one or two of you, Christine, maybe Laura, want to jump in.
It does make folks realize if you're going to expand into the US and you're going to need a new company, in a new US company for whatever reason, to buy real property, to operate as an operating entity, to have employees and bank accounts, whatever it is, you're going to have to plan in advance. It's always been that you have to plan your tax structure in advance before you figure out what kind of company you're going to have here. But I think it just makes folks take a step back and realize, let's get all of our ducks in a row. Understand that this is not something that's going to be done in 2 days, and so have realistic expectations and timelines.
My sense is that aside from the EIN, the corporation itself, the corporate entity can be formed relatively quickly. And then, registering to do business in the respective states, if it's not the state where you form the corporation, also is, a rather ministerial exercise. And so once the sort of tax considerations have been worked out, and the company's ready to go and to hire, and you've got that EIN and you've identified a payroll provider, you can get the basic mechanics of hiring up and running relatively quickly. If you've got the bank account and you've got a payroll provider, they can do a lot of the payroll provider will do a lot of the integration with the state agencies and the federal government, to whom payroll withholdings and taxes have to be remitted, and they will help you do your quarterly reports. So that most employers, in fact, I don't know any employer that runs their own payroll in the US. So that can be done quickly. We can prepare an offer letter very quickly if you're going to have like just a basic, employment arrangement. If you're hiring an executive and you're going to be offering equity in the company, options, restricted units, this is going to be for a term, they're going to be highly compensated. That takes longer. You have to build in time for the negotiation and for preparing all the equity related documents. Similarly, if you're going to have a key employee who's coming from Canada and is not a US person, you are going to have to take some time to think about what the right immigration strategy is, of course. And that can, if it's an immigration, if it's simply they need a work permit that can be obtained through, the categories recognized under the USMCA, that's quick. That's a quick process. If they need an H-1B visa, they're going to be some sort of skilled worker that needs some special authorization, that can take months.
And that's a good point too. Laura brings up the Hodgson Russ team does have an immigration arm as well. So something that, really gets a full service treatment from a firm like Hodgson Russ. Well, before we wrap, I just want to get one or two more questions. Another one that came in is for Mike. You mentioned some of those possible areas of litigation. Proposition 65 has some exceptions. For those other ones, like a slack fill, this question asks, are there any exceptions for the slack fill requirements or other litigation opportunities?
Sure. Yeah, I mean, slack fill is a good example of it. And there are always defenses to these cases that you can use, but slack fill is a good example because if you can show that the product settles during shipment, and that's the classic example of the potato chip. The reason potato chips are only half full in the bag is because they're pretty darn full when they package them, but then as they are shipped, they settle. Another is if there's a particular function to the slack fill. In other words, if it protects the product because of by squeezing the product, you won't damage it if there's slack fill. Another one is if the mechanics of the packaging process, if by putting more into the package, you would cause food waste. then you can use that. And companies try to prevent, if those are the reasons for the slack bill, they try to prevent people from suing them over it by putting, sometimes you see a fill line on a product, or sometimes you'll see a little statement that says product settles during shipment. So there are different ways you can mitigate the potentiality of getting sued, yes.
Great, thanks, Mike. And one more, this one I think is probably a good one for Nathaniel. What kind of contract protection would be available, if any, if we were to see another situation like COVID and border closure and border shutdown happen again?
There are provisions like a force majeure provision that were used more frequently in the last 2 years than in the entirety of my career combined. The tricky part about it is you need to spell out what events happen. So if you have the word pandemic or something like that, your life is much easier than just act of God. Christine, did you have anything you wanted to add to that?
Having the word pandemic or epidemic or something similar, supply chain type issues in your force majeure clause may be more helpful than not. So another good reason to kind of look at your standard forms and is it time to update them?
Great, thank you. And one last question, I can take this one, an easy one for me. It's, at what point as a company do we start talking to the experts? And what we would say here at Invest, and I'm sure the Hodgson Russ team would agree, the sooner the better. The minute you start thinking about expansion, it's just not too early to give us a call to get those questions answered, to get some information out of the way. And, as we wrap up, I want to thank everyone for joining us. And I know this is a lot of information to undertake, and I want to thank our Hodgson team for presenting it and providing it, but know that they are here and we are here to make things as easy as possible, to provide this information up front so that it doesn't feel daunting, that it doesn't have to feel scary, that it really can be a simple and easy process to get your business here set up correctly so that you can be providing the best product to your US customers and making your company as successful as possible. So with that, we're on a slide that lists everyone's email addresses, and feel free to get in touch with the members of the Hodgson team. But again, want to thank Laura, Christine, Mike, and Nathaniel for joining us today and providing such great information, and let us know if you have additional questions. Thanks, everyone.